And if the judges would please introduce themselves.
Hi, I'll be the lead judge for this round. My name is Michael DePiro. I work for the state of Florida with the Florida Department of Education in Tallahassee, Florida. And with me today is my two colleagues, and I'll let them introduce themselves, starting with Miriam.
Hello, I'm so happy to be with you all. My name is Miriam Marcidegi. I am a board member of the Center for Civic Education. I participated in We the People the first year it was offered on the bicentennial of the US Constitution, long time ago. I've spent a large part of my career focused on providing civic education to people living in the Middle East region, and particularly Iran. I'm originally from Iran.
Tandy, you're muted.
Try that again. Good morning. That happens to me a lot. Good morning. My name is Tandy Mcconnell. I served as a professor of history at Columbia College in South Carolina for about 20 years. And then about 3 years ago, I decided I wanted to do something more fun with my life. So I became a high school history teacher. And so I'm teaching history and social studies at Ridgeview High School here in South Carolina. And way long ago, I worked for several months in Cambridge, Ohio, down where everything is named for John Glenn. So I think I've been through Findlay, Ohio, but I could not find it again if you paid me. So I'm delighted to be here with you guys.
My name is Shane Reed.
I'm McLean Robertson.
My name is Abigail Powell, and our teacher is Mark Dickman.
All right, well, thank you very much for that. I'm going to get us started by reading the question and allowing you to start with your statement. So we are looking at Unit 1, the philosophical and historical foundations of the American political system. A question: Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? You may begin.
Mr. Chairman, habeas corpus is the legal procedure that requires a court to determine the legality of a person's detainment and is essential to limited government in that it prevents the unlawful detention of all people within U.S. jurisdiction. From its origins in English common law to the Habeas Corpus Act of 1679, the writ of habeas corpus and the conditions under which it can be suspended were one of the few individual rights included in Article 1, Section 9 of the Constitution. Because of this, to imprison a person, the writ requires more than just a sign of government authority. The writ of habeas corpus demands the government to show that the detention is based on duly enacted and enforced law, as seen in Ex parte Williams in 1833, when Thomas Williams was jailed for almost 6 months for his inability to pay a minor fine for playing cards. While habeas corpus and its application have changed over time, it has continued to provide limits on government actions, as seen with the 2007 Boumediene versus Bush decision, when the Supreme Court ruled that the Military Commissions Act of 2006 was unconstitutional, and that the government is required to show justification for the imprisonment of any individual in U.S. jurisdiction to prevent the deprivation of individual liberty.
Mr. Chairman, while habeas corpus is considered one of the great protections against arbitrary imprisonment, its evolution has been controversial. While the framers assumed that habeas corpus was a pre-existing right, they failed to clearly delineate the circumstances under which the government could legally suspend it. That led to President Lincoln to suspend its use in 1861. However, the courts would later rule in Ex parte Millium that habeas corpus could not be suspended if civilian courts were functioning. Congress then created the Habeas Corpus Act of 1867 to extend federal protections against the states to prevent the arbitrary detainment of former slaves. The use of habeas corpus expanded dramatically in the 20th century as lawyers petitioned for its use in federal courts to force states to conduct post-conviction reviews until the Supreme Court began limiting its use in the 1976 case of Stone versus Powell. Congress further narrowed its use within the Anti-Terrorism and Effective Death Penalty Act of 1996 in response to the Oklahoma City and the World Trade Center bombings. Finally, in the Guantanamo Bay cases from 2004 to 2008, the Supreme Court once again expanded the use of habeas corpus to apply to anyone under U.S. jurisdiction under the 14th Amendment's Equal Protection Clause.
Mr. Chairman, while habeas corpus has provided protection against arbitrary imprisonment, its overuse in the application of constitutionally protected rights under the 14th Amendment have become problematic. With the passage of the Habeas Corpus Act of 1867, the federal government extended its use against states in order to prevent the detention of those who were once enslaved. However, this act also enabled federal courts to intervene in cases that were previously concerns of the states, as seen within the 1923 case of Dempsey versus Moore, whose attorneys successfully argued against the unlawful detention of their clients and gained a post-conviction review for death row inmates to determine if the trial was fair. However, this use of habeas corpus has created concerns about delays in the application of justice, with petitions clogging the federal court dockets and prompting questions about how far the federal judiciary should be involved in criminal justice, historically a responsibility of the states. Despite all the legal maneuvering regarding their use, the vast majority of petitions fail to prove a legal or factual error. In response, Congress passed the Anti-Terrorism and Effective Death Penalty Act of 1996 in order to limit their uses in capital cases.
Well, thank you for that opening statement. I'm going to let my colleague Miriam begin with questions.
Okay. You've laid it out nicely. Let me ask you a question that kind of extrapolates from what you've put out there. Do you think that these due process protections make the United States a stronger country in terms of our stature in the world, in terms of our economic ability? How do we compare with other countries in the world because of these protections? Consider, for example, also that our chief adversary, China, does not have these protections.
Madam Chairman, what differentiates America from other countries because of our habeas corpus is it strengthens our free society, and it allows us to have more faith that our government isn't going to turn on the people and isn't going to imprison us if they don't like what we're saying. And that really just is one of the biggest things that we can highlight. It maybe might tie up our judicial systems at times, but it's important that we remain a free society.
Madam Chairman, to add on to that, I do believe that's what keeps America so great. One of the many advantages of living in America is the freedom we get, and to add on to habeas corpus being available to us, I think that that's a right that we can take advantage of instead of, like, China doesn't have it, but we do, and I think that's what keeps America so great.
Let me follow up with that. Habeas Corpus Act of 1679 is where where the question began. What were the circumstances of the creation of that act of Parliament, and did the idea of habeas corpus, did it pre-exist 1679?
Mr. Chairman, habeas corpus did pre-exist the Habeas Corpus Act of 1679. It originally was found in common law, and there are some provisions in the Magna Carta that can be related to habeas corpus. It was mainly enacted into law by the act because mainly lords and barons feared that the king would implement laws and would imprison individuals that he didn't simply agree with.
Mr. Chairman, to keep in mind with that, even today, we're still revising and adding amendments. So just for another form of habeas corpus to come out, that's just how the government works, and just revising and making it more clear to what we needed in the world.
Mr. Chairman, we do have a case previous to the Habeas Corpus Act of 1867 in Darton's case, where we see King Charles I arresting 4 knights who were unable to pay a fine that was imposed upon them. And in this case, we see a very early use of habeas corpus, allowing these people who were wrongfully imprisoned to state that they were wrongfully imprisoned and allow them to step forward and be freed from this unlawful detention.
Mr. Chairman, I do want to add that it's Darnell's case.
Thank you.
So building on the application, in a modern context, when would the government, and there's a constitutional answer to this, so take the constitutional answer and apply it modern context. When would it be constitutionally allowable to suspend habeas corpus in a modern example today, 2021?
So, Mr. Chairman, a modern example today where the suspension of habeas corpus could happen in Article 1, Section 9, in case of invasion or rebellion. We could interpret the January 6th attack on the Capitol. We can interpret that to an extent as a rebellion or a revolt in a sense where we could, because there were so many individuals who were at the Capitol building on that day, it would take time to move through the court process and the due process. And so by extending the amount of time these individuals would be imprisoned, that could be acceptable under the Constitution to an extent.
Mr. Chairman, to look back on society, on how when we have suspended it, it's only been in absolute times like President Lincoln.
Mr. Chairman, I would also like to add that the suspension of habeas corpus was also found in Hawaii soon after Pearl Harbor, and we can see in time that this was actually deemed unconstitutional. So it is worth noting that while there may be times where initially it was seen as important to suspend habeas corpus, as time goes on, we see it as a very valuable right that must be carefully reviewed to make sure that the people are protected from arbitrary imprisonment.
So using January 6th, and habeas corpus wasn't suspended then, but a New York City judge, I believe, did suspend habeas corpus in the wake of some unrest in New York City. Is that a lawful suspension?
Mr. Chairman, in reference to the case of which you were referring to, I believe that in that position, this judge was justified in doing the rather unlawful arrest of these individuals due to the circumstances surrounding the supposed attack at the time. This was during the middle of the COVID pandemic, and a lot of people were worried about the health safety of the public at the time. So with these riots outside of the New York City Police Department, I do believe the judge in question was justified in protecting the general public from a raging riot.
Thank you. I'll yield to my colleagues if there's further questions from them.
Is there a difference between simply being able to arrest people who are where they're not supposed to be and being able to hold them without the obligation of without the burden of habeas corpus? What's your feeling on that? Because that seems to be what's at stake here.
Are you saying the difference between arresting somebody and arresting somebody without the right to habeas corpus?
All right, arresting somebody and holding them for an hour or a day or a week, and then say, "Oh, you know, go home," or arresting somebody where habeas corpus is not in effect. What is there a substantive difference there?
There is a
substantive.
substantive.
1 minute to resolve that huge problem.
I'm sorry, I didn't see. Did you hold up the 1 minute or time button?
It was 1 minute.
Okay, sorry. In a society such as the Chinese government, where they don't have the writ of habeas corpus, it could be any criminal offense that you're charged for, but you don't know what you're charged for, and you're not going to be given the right to figure that out and a right to plead your case. You could be charged indefinitely, and that can silence your voice, and it can create massive human rights violations. But with a society with habeas corpus where you are imprisoned and you do have that right to be brought to a court that's impartial and unbiased, you can plead your case. And we even have the media today, which can, and public court records that can bring light to even the most unlawful cases and really sway public opinion.
Time.
Great place to end.
All right.
All right, well, thank you. Thank you for all the preparation.
Thank you.
Thank you very
And-
much.
your ability to think on your feet, your eagerness, and your being a real team. I mean, it's clear you guys have been working together. You've been working well together. You're supporting each other. It's fantastic to see. Our questions were all over the place, and you managed to, traverse all that terrain. You guys have a lot to be proud of, really. And your teacher, Mr. Dickman, congratulations to him also.
Thank you.
Thank you very much.
So I'll provide a little bit of feedback, but before I do, I want to know how harsh I need to be. So could you tell us where you're going to go to college, and we'll judge our feedback based on that?
Is that a rhetorical question, sir?
No, seriously, where are you going to school? We're always curious.
I plan on going to Michigan University. I hope to go into the medical field.
Political science at Ohio State.
Social work at either Ohio State or Findlay.
Well, I feel like you got the university wrong. Isn't it supposed to be the Ohio State?
The Ohio State University.
Just asking for a friend. So two pieces of feedback. The first is a technical piece where I would like to commend whoever set up your technical setup, because sometimes with a setup like yours, it's echoey and it doesn't come across as well as yours did. So wherever the microphones are placed or however you did it, it was a nice job. The second piece was to the gentleman to my left, I guess to your right, your answer, and I guess as a whole, your answer to two politically underlying charged events, January 6th, as well as I believe it was Black Lives Matter incident in New York City, was unpolitical in your response, and you stuck to a constitutional basis for your reply, and there was no hint of bias in a direction that was politically motivated, and that is not always the case, especially with ongoing events. So I would also like to commend you all for sticking to the principles in the Constitution. So Tandy?
Yeah, it was great. You did an outstanding presentation. You made general statements and then you supported them with solid evidence. You're I think not, you did well, let me start that sentence over again. You did a great job of presenting talking about the Act of 1679. That's what the question's about. And a lot of people seem to be just sort of going out there and moving on quickly. But the circumstances of that act were important. It was a pre-existing idea, but it was not really solidified into law until then. So common law is one of those really tricky things in American and British jurisprudence because it's subject to, it is what the courts have said it is, and courts can change their minds once Parliament establishes it as fact. In the aftermath of the Glorious Revolution, then it becomes something that British Americans are going to take as one of their basic rights. And so when a British American in 1770 felt like his or her rights to habeas corpus were being infringed, they're going to make sure that's explicit in the American Constitution. Great job, great presentation, and wonderful having a chance to talk to you guys.
Thank you.
Thank you very much.
Yeah, we just want to congratulate you guys on participating and thank you. Wonderful job today. Thank you.
Wish you the best.
Thank you.
We appreciate that.